as an aid for the defense of this horrible prosecution. So here in the first two counts, obviously highlighted, we see where it says concerning a lawsuit that was previously resolved by the judicial system, and then from a lawsuit that has been previously resolved. That's just a bunch of nonsense, and we're going to dive right into that. Basically what I'm going to be attacking here is the 2018 final order granting defendants joint motion for summary judgment. So right here on the first page, we have where the father and stepmother submitted a statement of undisputed material facts. Okay, those are simply very disputed facts, highly disputed. So I'll go to that next. So here's their joint motion for summary judgment. We'll go down here. Important stuff, dealing with the $10,000 in the inheritance. And here we go. So he says she, referring to my Aunt Lila, designated the defendant Wesley Schuessler as the custodian. Never happened. Under Alabama Code Section 35-5A-19, paragraph B, he would have needed an instrument of designation and a letter of resignation. Same thing for the Georgia Uniform Transfer to Minors Act. And I'm also pretty sure the will requires something similar. Right here, Alabama Uniform Transfer to Minors Act. It was not the Alabama Uniform Transfer to Minors Act. It is the Georgia Uniform Transfer to Minors Act. That's what the charter bank records say. That's what the checks say. And that's what the law allows. The law, under the circumstances, if he was proper custodian, he would have been allowed to make it a Georgia Transfer to Minors account. And, he just is lying. And he says, when the estate settled, check was issued as part of the final settlement of the estate and before the plaintiff's 19th birthday. That's half true. It was issued before 19th birthday, but it wasn't issued as part of the final settlement. The final settlement was May 2012. My 19th birthday is April of 2012. Therefore, if he was designated as custodian, he would have had to give me the money a month or two later anyway. And again, Alabama Uniform Transfer to Minors Act, not true. So we go up here, written report. That comes into play with the statute of limitations. Okay, if he gave me a proper written report that disclosed facts that would give rise to the claim of breach of fiduciary duty, then it's a 2-year statute of limitations from the time I received that report. Okay, first of all, what he gave me is a deposit slip. Georgia case law says that's not going to qualify as a written report under the trust statutes. Okay? Second, he gave it to me in March of 2012. My claims come from July of 2012 and from 2014. How could a report issued in March of 2012 disclose something in July or later of that same year? It just doesn't make sense. That's his logic. There is none. Begin distributing the money to plaintiff through written checks endorsed and then cashed by plaintiff. That never happened once. He wants to impute on me that I had this knowledge of the account and that I knew it was really a Georgia account. And you'll see later in his affirmative defenses where he claims doctrine of unclean hands and things like that. That's probably what he's trying to set up here. But yeah, these are lies. And then Wesley Schuessler distributed all funds due the plaintiff under the terms of their written agreement and court order with the last distribution in 2014. First of all, no, last distribution was September of 2013. That's not true. And he did not distribute all funds due under the terms of the agreement. We'll go back one page, and here's the agreement. It says, balance in account, less $1,000 to attorney. Now this is misleading, because this is where that $1,500 that I never knew that went to the attorney hides. It hides right here where it says balance in account. And that's slight evidence of fraud, and in Georgia that's enough. But I'm not claiming fraud. But balance in account, I would have had a different idea of what the balance in the account was than what it actually was that day, shall be divided by 16 months and paid in equal installments of 16 payments beginning January 5th, 2013, the balance being in that account. And then plaintiff shall not be allowed to seek or obtain any other amounts if either party attempts to obtain other funds from the trust. Yeah, I don't really care about those provisions of it. I'm kind of just interested in this right here. He paid himself $100. Now you may think, well, that's $100. A long time ago. Who cares? I care because I am very confident that he didn't just give himself $100 because he thought he did a good job as trustee. I think he was reimbursing himself for a March 21st $125 payment. Now, a March 21st $125 payment would be 6 days. I don't know if you can see this cursor, but right here on paragraph 53 on the left side, the check was deposited on March 27th, 2012. Well, then how in the heck did I get a payment in the exact amount that all these scheduled deposits would be on March 21st that was set up and looked basically like Wes was paying me from my inheritance? He made the impression that he had my money lawfully and that he was paying me money before he even opened this account. I mean, that's ridiculous. And that's why that $100, it all doesn't sit right with me, but that especially. I'm very confident that $125 he paid me into my personal checking account, he just did like a sneaky little direct deposit. He had called me one day and said, I need your bank info. I've got your inheritance, and I'm going to start giving you a little bit of money, or whatever he said. I mean, there's subtle lies sometimes, but they have profound impact. So that was disputed facts. That's literally just the disputed facts. So we go on to page 2 here of the final order granting summary judgment, and defendants also substantiated multiple affirmative defenses. Affirmative defenses equal proven untrue. So let's go check those out. So here we go to the answer, and let's note this down here in the red. Defendant denies he owed plaintiff a fiduciary duty. As a former lawyer of 16 years, this man denied that being trustee wasn't a fiduciary duty. Are you kidding me? I mean, come on. Is this the Twilight Zone? It's been 4 years and this lie is still believed by Carroll County? It's just ridiculous. Getting frustrated. So let's go to the affirmative defenses. Number 1, the claim for breach of fiduciary duty, blah, 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 because of plaintiff's prior lawsuit. Okay. Defendants are not liable to plaintiff on these claims. In July 2012, the plaintiff sued the defendant in the District Court of Lee County. Yeah, that's not really true, because Wes made it so that he was at all times sued as trustee. And if we'll go over here one, we'll see that different identity of the parties. Okay, this is Georgia case law. Says, but the parties are not the same, nor are the issues the same if in one case the defendant is sued individually, and in the other case he is sued in a representative capacity. It means that he was two different parties in each lawsuit, so he's no res judicata there. Also see Restatement of Judgment, Section 36, says the same thing. But nonetheless, allegedly, defendants proved multiple affirmative defenses. So we'll go on to 2, because 1's completely false. Plaintiff's claims are barred by the applicable statute of limitations and latches. And this one right here, he pretty much stretches. I admitted in my complaint that a few of my claims were pretty much outside the statute of limitations, but that I was a complete novice and didn't know how anything worked, and that if they could be told, I would like them to be told. Obviously, they could not be told. Now that I know how law works, that was kind of stupid, but I don't feel bad about it because I didn't know anything and shouldn't expect to know everything like that. I mean, I kind of had an idea at the time that it wasn't going to go through, that they were outside the statute of limitations, so it wouldn't work, but I didn't really know how tolling worked, so I was just asking for equitable tolling. So that one's not true to the breach of fiduciary claim, and that goes back to that written report where instead of it being 2 years, it's 6 years from the time I discover or reasonably should have discovered that there was an issue. And I didn't reasonably discover that there was an issue until 2018, and that gives me until 2024, and it's only 2022, so you can see why this dude's ducking for cover. But we'll go to 3 here. Defendants plead the defenses of equitable estoppel, collateral estoppel, judicial estoppel, or issue preclusion. Okay, that again, you need the identity of the parties for that under Georgia law, and you don't have the identity of the parties. So that's 3 in a row that are not true. So I'm waiting for one of these affirmative defenses to be proven true. Defendants plead the defense of accord and satisfaction and the defense of payment in full. Well, that right off the bat, that $100 means this defense is not true at all. So he's 0 for 4. And then 5, this is my favorite. To the extent the plaintiff the plaintiffs, there's only one plaintiff, make claims for mental anguish or emotional distress, defendants aver that any award, this is just some weird constitutional claim that he made that I don't think is any good, but I'm not 100% sure, but it's just goofy, and the court definitely didn't rule on it. And then we go here to 6, 7, 8, and all the way up to 39 or whatever it goes to, and they're just statements. Nowhere did we talk about any of these. We didn't talk about them at the hearing on September 17th, 2018. They're not explained in the final order. He just literally wrote things like, plaintiff's claims are barred by waiver, and then Wes got to write the final order, which he typed the entire final order, and I can prove that to you, because if we go to the final order, Judge Duffy wouldn't have not known who he was. He would have, or his assistant, if somebody typed this out for Judge Duffy, or Judge Duffy typed it himself, he wouldn't have typed Judge Dustin Hightower. That's a Wesley Schuessler mistake right there. Okay, so Wes wrote all this. He wrote these lies, and they were accepted by the court. But, so nowhere does it prove that plaintiff's claims are barred by discharge. It just says that here, and then Wes got to write the final order and write it how he wanted to. I think that might be about all I got, but